ladies and gentlemen. At the outset, I must express my thanks and gratitude for having me given this privilege and opportunity to be here and to share some of my thoughts on the topic entrusted to me. It's really tricky topics of the POCSO Act, Section 29 and Section 30, dealing with the issue of presumptions. When this act came into force, at the very beginning, I can remember there was a deliberations in Guwahati, attended by and I was also not very convenient to see these provisions, because having considered the basic principles of administration of criminal justice prevalent in our country. Anyway, to understand the concept of presumption, because as you all know, presumption is also a rule of evidence and is associated with the burden of proof. So burden of proof, all of you know that it is the principle or responsibility on whom the burden lies to prove a fact. Somebody comes to the court and desires that the court give a verdict in his favor. Law says it is his burden to prove. But the Evidence Act, this is the general burden on whom it lies to prove a fact. If we read Section 1 to Section 6 of the Evidence Act, Section 1 and 2 basically deals with the general burden of proof on whom the burden lies. Section 3 to 6 deals with certain specific cases, particular circumstances, which says that despite the principle of general burden, under certain circumstances, burden lies on certain specific persons. Now, if you read Section 101 of the Evidence Act, this is the first provision, which reads, because time is short, I will try to concentrate on the criminal side only, because Evidence Act is not only for the criminal law, it is for both civil and criminal, but I will skip the civil aspect of the matter. Whoever desire any court to give a judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove that those facts exist. When a person is bound to prove an existence of a fact, it is said that the burden of proof lies on him. Illustration, as all of you know, the illustration has the same force of the statute. A desires a court to give a judgment that B shall punish for a crime which A says B has committed. Now, A must prove that B has committed. There the must, the word is very important in criminal cases. So, if A says that B has committed a crime and desires the court should punish him, it is A's burden that he must prove before the court that it is A or B who has committed the crime. This is, we call in the common legal parlance, the initial burdens. This burden never shifts. Once it falls a person, it remains throughout the trial on that person's. You are also aware of a concept of onus, though there is a very fine distinction between onus and burden. Sometimes onus keeps on shifting. In civil law, it goes on shifting from this party to that party to this party. But in criminal law, rarely it shifts. Then there is another provisions which is little bit though it will not be proper to say exactly at exceptions, rather I can say it's an addition. 106 of the Evidence Act, which all of you are aware of, the judicial officers, that these provisions is intended that under certain circumstances, there is a change of onus. Now, even if in a criminal case, as I have read the first provision of 101, that the burden lies on the prosecution. Prosecution must prove its case. But there may be certain circumstances where things may be such that which is exclusively within the special knowledge of the accused or the person who is being prosecuted. Then, in a circumstances, the onus shift to that accused to prove it. Now, superficially it appears that it contradicts with the basic principle of criminal justice, that the burden is only with the prosecution to prove. There are some other fundamental principles of the criminal justice I will deal little later. Now, I give an example. Suppose an incident happened within the four corners in the house at night. Nobody was there. Only the perpetrator, supposed perpetrator, I can't say perpetrator at this moment, or a man who has been accused of that commission of the offense, and the victim. If that fact is proved, and it is proved that he was there at the relevant time of commission of offense, and none else, so it is only he who knows, there is no others. So these provisions law cast a burden on him to explain. He can say, no, though I was there, I am not the perpetrator. So unless he explain how it happens, then he cannot take, in the circumstances, recourse to the principle of, the presumption of innocence. Because in that case, presumption of innocence, which is not only Indian criminal jurisprudence, it is an almost globally accepted, it is said to be human rights, a part of it, is an important facets of the human rights, get limited. At some point of time, he may be deprived of that right to be presumed at innocence, unless he explain the circumstances. If he can explain the circumstances and can show that yes, he is not well, he can get the benefit. But in that circumstances, he cannot take recourse to the principle or the right of presumed innocence. You cannot. So this is called, otherwise called, it's a reverse burden. Burden get reversed to the accused. Though under the criminal law, initial burden is always on the prosecutions. Now, there is a philosophy behind this. Why this burden is reversed to the accused? There are two aspects. One is social aspects, which is the primary, because society and the state, it is the responsibility of the state to protect the society, to protect the marginalized section, to protect the women, protect the children, protect. So in a circumstances, some protection is required. Because this is also, don't think, this does not violate the constitutional provision also, section 15, section 14, section 21. Because Article 15, not section 15, Article 15 itself, subsection 3 says that state can legislate, made some special law for the protection of childs, protection of women, so and so forth. So though apparently it seems to be not in conformity with the general principle of criminal jurisprudence, appears to be there some discriminations, but it is within the permissible limit. Constitution allows this state to make the special law with the special provisions to serve the best interest of the society. So this is how this reverse burden or shifting of a burden under special circumstances is permissible. So before going to presumption, we must understand one more things. One aspect of the criminal law is on whom the burden lies, who has to prove it. The other aspect is how to prove a fact. What are the materials required to prove a fact? Judicial officer, all of you know, there are 6 things by which a fact may be proved before the court of law. Oral evidence, documentary evidence, material objects, admissions, judicial notice, and presumptions. These 6 tools before the court by which facts can be proved before the court. Now, so presumption is also an efficacious tool before the court to prove a fact. It is not always that the fact has to be proved positively either in existence and positively either in not existence. Presumption, all of you know, presumption is nothing but an inference, suppositions drawn from some facts which are proved or which are known. So one thing is clear, that there cannot be a presumption from a presumption. So in order to draw a presumption, there has to have some facts proved. There is no question of assumption. Those facts on the basis of which the presumption shall be drawn, or anyone can draw the presumption, any prudent man, that facts has to be there. If those facts are absent, if those facts are not proved, you cannot draw a presumption on air. So there has to be, you all know that there are some presumptions are mandatory, some presumptions are optional, some presumptions are given directly the status of evidence, conclusive presumptions. So presumption is also an important tool, I am stressing on it, to prove a fact. Now proving a fact before the court, not only to say positively that it does exist directly or that it does not exist, right? Now you have read this definition of proved. How a case is proved. The definition of proved, all of you have read it, I just for recollection. A fact is said to be proved when, after considering the materials before it, mind you, the court believes that it exists. This is direct. The court, after considering the materials before it, the court believes that it exists. Someone comes to the court and says that A has killed B, so court believes him, yes, matter ends, A kills B. Then, or that evidence may not be in all cases. Then what says? Or consider its existence so probable. See, though we say this beyond reasonable doubt, there is no scope for discussion on all these things because it will be lengthy. So, you see two concepts, belief, the court believes its existence, that it exists, or it consider its existence so probable that a prudent man ought, you see, now you see, by the standard of a prudent man, not by a very high standard, not by a very low standard, ought, under the circumstances of a particular case, to act upon the supposition that it exists. So, the court suppose, court presumes, court infers on certain facts, though it is not directly proved that A has killed, but all the facts that has been proved that indicates that in all probability A is the person is doing the crime. So this is another aspect. So we should not be, in a area that beyond reasonable proof only refers to the belief of the court directly that it exists. It also refers to the supposition, and that too by the standard of a prudent man, not by the standard of Einstein, not by the standard of anybody else who have a very high, intellect, not even the low. So common. Therefore, when the matter is required to be proved before the court, particularly I am telling the judicial officers, so we must keep in mind, so it is the belief of the court, this is one thing. If the court believes that it exists, matter ends. If it is not in a position to that it believes that it exists, but he can suppose, he can presume that yes, in all probability it is so. So this is another way, this is how the presumption. So the presumption, though it is not a direct evidence, in all cases it may not be an evidence also, but at times it attains the status of an evidence and enables the court to decide a matter and they give the verdict, yes, it exists. Once the court comes to a finding, either directly it exists or on the suppositions on all materials that in all probability it exists, or fine, okay, fine, court can deliver the judgments. So this is how we have to understand what the presumption means and what is the, the evidentiary value of a presumption. Now, this sort of presumptions, not only in this POCSO Act, you find in many other acts. You find in the NDPS Act, Section 35, Section 54. You find in the Prevention of Corruption Act. You find in the Negotiable Instrument Act, so on and so forth. You find in the IPC 304B. You find in the Evidence Act 111 to 114. Then there are other provisions also, 113A, 113B, and many other provisions. So these all deals with the provisions, presumptions. Only one thing, the basis of presumptions, what factors required to take the presumptions are explicitly deals in almost in all the states. If you see the POCSO, the NDPS Act, it says if the possession is proved, then there will be a presumption that his possession is illegal, he is possessing contraband, contrary to the law. So the illegality, contravention of the law shall be presumed. This is not in any other case, may not be. So NDPS Act itself says that in order to draw a presumption that he has committed the offence, if these two facts are proved, then there can be a presumption. Of course, there does not ends, Because all of you know that every presumption is rebuttable. Be it mandatory presumptions, be it optional presumptions, even the conclusive presumption also sometimes have got the windows for presumption. For example, I can say 112 of the Evidence Act. There is also a small window, though the definition of section, now it is section 2 under the Bharatiya Sakshi Adhiniyam, BSA, under the Evidence Act section 4, the definition says conclusive proof, no evidence, court would not allow evidence. Law says if A, B, C is there, D is proved. You are not allowed to adduce evidence. But in such case also, you read the section 12, you will find there is a window. Even that presumption is liable to be rebutted. So all presumptions are subject to rebutted, be it statutory presumption or legal presumption or mandatory presumption, whatever you say, or shall presume or may presume. Only difference is when it is may presume, court has the option. Court may presume, court may not presume. But when it is shall presume or mandatory sort of presumption, or we call it legal presumption, court is bound to presume. See, when that facts A and B is there, and it says the court shall presume, the court is bound to presume that yes, unless and until that presumption is rebutted. Because that option will always, accused will always have. Because that is in conformity with the right of the accused. He must have his say. He can rebut it. So, but if you read, the section 19, this provision is little bit vague. It says when a person is prosecuted. What do you mean by prosecuted? It does not say that if A fact is proved, B fact is proved, C fact shall be presumed, like NDPS Act, like the Prevention of Corruption Act, like 113B, like 304B. There says 304B, if the marriage is within 7 years, the occurrence is within 7 years, the torture, cruelty, demand, and all these things immediately before death, if these three facts are proved, then court can presume that it is a case of dowry death. The problem with section 29 is that it is not that explicitly says that on what basis the court will presume. It says that when a prosecuted. So what does the prosecution mean? Does it filing the FIR? Does it mean the filing the charge sheet? Does it mean filing the complaint only? No. But that has been discussed by the Supreme Court in many decisions. All of you must be knowing that Nuraga case, because though it has not been mentioned here what the prosecution means, prosecution does not mean mere filing the charge sheet or mere filing the complaint or mere lodging the FIR. Prosecution means those facts which are required primarily has to be proved. Here, while we understand or analyze the section 29 of the POCSO Act, we must be careful of some of the fundamental principles of criminal justice system. One, I have already said, that the right of the accused to be presumed innocence. Accused has a right to keep silent. He can say, I will not say anything, prove you, because it is your burden to prove. I have a right to remain silent. Yes, you have a right to remain silent. Burden is of the prosecutions. I have to be presumed to be innocent. But the special provisions when says that a presumption, when some facts are proved, that right to presume presumptions at one point of time come to an end. putting a corresponding burdens of the accused to explain those, to rebut that. Unless he can rebut, presumption will prevail. Then the court can pass a judgment even on the basis of presumption. At the beginning I have said that the presumption is an assumption, is an inference. You can ask how it can be accepted, because law says that the offense has to be proved by beyond all reasonable doubt by the prosecutions. So I just now I have read the provision of the definition of proved. It has two parts. So under certain circumstances, the POCSO is one of the very vital act, special act, enacted for protection of the child, the women, child, because it's a gender neutral act. POCSO is a gender neutral act. It may be a male child or maybe a female child, does not matter. And this act is also in conformity with the constitutional mandate. So nobody can challenge it. It was challenged that it violates the constitutional, right. But the court has said no, because it is at par with the, in consonance with the constitutional fervor. Now, how you take the presumption? So the basic question is, when the presumption under section 29 operates, when court will presume it. There are one judgment of the Guwahati High Court, only one judgment I could lay my hand. There are laid down the principle, I will tell you, some of you may be knowing also, Bhupen Kolita or something. I will give you the citations. So even in the POCSO case, if you want to make a presumption, mere filing of complaint, all that, yes, I have filed the submission, prosecution is all that, I have prosecuted. Let the accused disprove it. No. Mere filing of charge sheet or complaint will not do. The initial burden has to be discharged by proving certain fundamental facts. Foundational facts, not fundamental, the appropriate word will be foundational facts. If those foundational facts are proved, which does not prove the case beyond reasonable doubt, but only raises a presumption on the basis of preponderance of probability, in absence of any other evidence, court is 100% right to convict merely on such presumptions, unless it is rebutted. So we have to be careful only that one thing, section 29 or any other presumption for that matter does not absolve the prosecutions from its initial burden to prove the foundational facts. Suppose there may be situations, it may not be possible for the prosecutions to prove all things in a positive manner. But prosecution proves that a violence has been made on a child. A child may be a very 5 years, 4 years, 3 years, maybe he may not be in a position to talk even. There may not be even an evidence of the child. May not be. Does it mean only because the evidence is, child evidence is not there, the accused will scot free? No. So if it is proved by the prosecutions that violence was done, or the child is subjected to violence, it is of that nature, or some other facts which indicates that not must, maybe, accused may be associated, that is sufficient. If these fundamental facts are, foundational facts are proved, court is able to take a presumption. Therefore, section 29 only by way of reverse burden puts a corresponding burden of the accused once that presumption comes into operations by way of proving the foundational facts, then the burden shifts to the accused. Then accused has to disprove it. If the accused fails to disprove it on mere presumption, you can convict. That judgment cannot be challenged, that it is not beyond reasonable doubt. It is not necessary. Because this is a special legislation with a special object. It has been created to protect a marginalized section of the society. So court must be very sensitive while dealing with a POCSO case. You cannot be very mechanical. You must be sensitive. You have to scrutinize the evidence. Now, you see, section 29 is a rule of evidence. And the process of trial is a different thing. When you consider whether you will presume or you will not presume, it is only at the end of the trial. So by this time evidence is on record by the accused, by the defense. Then when you appreciate the evidence, then when you appreciate the evidence, when you weigh the evidence, and you find that the prosecution at least has proved the foundational facts which suggest that A may be the perpetrator, though otherwise must be, there is a Supreme Court says there is a long distance between may and must. So convict a person, the prosecution must prove. So it could be proved that he must have committed. Here, you are allowed to convict only on maybe. You need not wait for must. But if the accused also adduce evidence, either by way of cross-examinations or by adducing his own evidence, dislodge, rebut, right, the evidence or materials sought to be produced by the prosecution, then section 29 vanishes. And in that case, the prosecution has to prove it beyond reasonable doubt. So one thing is, it operates at the time of appreciation of evidence, because presumption is a process of analyzing the evidence. It is not that some evidence is there, then you presume, then you ask other party. It's not that, because it always comes at the end. So if the foundational facts which goes to show by the standard of preponderance probability that A may be, the initial burden of the prosecution stands discharged. If the matter remains there, no further evidence, court can convict very well. But if the evidence is there, rebutting those facts, then also not that you will have to acquit. Then burden becomes stringent for the prosecutions. Then they have to prove beyond doubt that yes, he has committed the crime. So these two aspects we have to understand. Sometimes what happens, you try a POCSO case and you find that very important ingredients of the POCSO Act, the aged, is not proved. Or it's a marginal, border state. Or by evidence it is proved that the victim is major. So you need not sandbag the case. But only thing is, so mind you, don't confuse this with section 42. Section 42 is something else. Section 42 talks about the alternative punishment, means sentence, conviction then sentence, the two different stages. Once the conviction is there, then the question of sentence comes. Unless there is conviction, there is no question of sentence. So we want to convict. Suppose you find that this age of the victim is above 18 years, so it does not satisfy the most important ingredients of the crime, any crime, not only the 3, 5, 7, 9, 11, all offences under the POCSO Act, because he is not a child, he has to be child. All of you know that in that case, you can convict him under the IPC provisions also. Though you are trying a POCSO case, mind you, you cannot invoke section 29. As soon as the ingredients of childhood is gone, it appears to be a major, and you decide to convict him under any provisions of the IPC, then section 29, section 30 vanishes. It does not operate. Another questions I just want to deal with, because that is very often raised. Suppose you are trying the accused for any offense, 5, 7, 9, 11 and so on and so forth, and no charge is framed under the IPC. It may be difficult on your part to convict under the IPC sections, because the ingredients are different. Because one of the very vital ingredients under section 376 is the consent. If the sexual act happens with the consent, with two measures, it's not an offense. It's not an offense. So consent being a very vital ingredients of the offense under 376, therefore it is advisable for the POCSO judges, at least in the cases where you have a doubt, suppose the 17 years, 16 years, so this type of cases, you always frame an additional charge under the IPC provisions. Then accused cannot raise the plea that I have not given the opportunity. If you do not frame that charge and straightway convict the person under section 376, he may challenge it and says that that charge was not framed and the ingredients of two charges are quite different and no presumption is permissible under that act, so the conviction itself is bad. So in marginal cases where there is doubt that the age may not be proved to be a child, it's my request to all the special judges, you always frame a charge under section 3 under the IPC. It is not necessary that you have to frame the charge at the beginning. Even at the end also, while hearing argument, you find that this is a case where the juvenility or childhood is not proved. You can frame a charge and that stage also and proceed. There's no bar about it. You give an opportunity. Yes, I have added a charge. All of you know the section 16 onwards. Now perhaps it is under the new law, maybe section 39 onwards. You can frame. So convictions and punishment are two different things. So please don't, misunderstand this conviction with the punishment that has been dealt with section 42. Section 42 deals with once the conviction is attained and the stage of punishment or sentence receives, the provision says you are to give the higher punishment when both the ingredients of the offense under which the accused has been convicted There is also a contemporaneous offense under the IPC of common ingredients, same ingredients. Then you can punish him, sentence him under the IPC provisions if that punishment is higher. Otherwise, if the ingredients are not same, section 42 also does not apply. Section 42 also does not apply. Therefore, presumption under section 29, as I have already mentioned, just to recapitulate, it does not mean mere filing of charge sheet, or it does not absolve the prosecutions from proving the initial burden. It also does not, say that all the fundamental principle of criminal justice will not be there, but there will be only some restrictions. So, section 29 of the evidence is the POCSO Act does not absolve the prosecutions from its burden to prove, it only lessens its burden. Prosecution's burden is to some extent lessened in this case, that even they can prove to the extent of preponderance of probability, assumption, probable, highly probable, and there is no further evidence, you can go ahead with the convictions. But if that foundational facts are not there, mere the filing charge sheet and all these things, the presumption will not operate. You cannot take the presumption, because in the beginning I have said the presumption cannot be on presumptions. Presumption has to be on the basis of some proven facts, on the basis of some known facts. If those proven facts in the form of a foundational facts of a particular case is proved, then only the presumption will operate. Otherwise not. Otherwise you will know the general principle. You have to prove beyond reasonable doubt. No doubt. So that is only, you say, in one word, if I can say, section 29 lessens the burden of the prosecution in a POCSO case to prove a case. And that has to be filled up by them. And in this section 29, the burden of the accused to rebut the presumption is not beyond reasonable doubt, unlike section 30. So here, the standard of evidence that has to be proved by the prosecution is preponderance of probability. But section 30 talks about another presumptions. This talks about the mental state. You see, knowledge, intention, belief and all these things. You know, section 7, with the sexual intent. Section 11, right? So when the law says, if the touch, you have been hearing the bad touch, good touch. So if there is something, some behavioral aspects, if it is bad touch or it comes under any of the provisions, that act is proved, court will presume that it was with that intention. So that intention, say for example section 7, intention with the sexual intention. So that will be presumed, that need not be proved. Once the fact is proved that he has assaulted, he has touched, he has done something, that part, though it is an important ingredient that the intention has to be required, that intention shall be presumed by the court. And the burden is otherwise. Accused has to prove, yes, though I pat on his back, right? He says, no, I love him, I love her, I just pat on her back. So he has to prove it beyond reasonable doubt, not by preponderance of probability, mind you, that my patting on his back was not associated with any sexual intent. He has to prove. And that proof is not by preponderance of probability, which is in general cases the burden or the defense, proof of defense is always preponderance. But here, though he can come with a defense that my intention was good, my intention was not that, he has to prove it beyond reasonable doubt that his intention was not that. That is the difference between the burden of defense in a criminal case in section 30 of the POCSO Act in other cases. Here he has to prove by a positive evidence, strong evidence, that he did not have the intention. Otherwise, court shall presume. So two things, keep in mind that presumption is also an efficacious tool before the court to prove a case. And for presumptions, be it POCSO, be it NDPS, be it Prevention of Corruption Act, some foundational fact, the basic burden of the prosecution has to be discharged. Unless it is discharged, presumption will not operate. Once that burden is discharged, to the extent the circumstances of the law requires, presumption will operate. Once presumption operates and its remains unrebutted, you can go ahead with the convictions on the basis of presumption alone. You need not prove beyond reasonable doubt. Only when the presumption is rebutted, then only go to that extent. So I will stop here because this is a very important topic. I want the floor to open. Any questions on this subject? Because already we are behind the schedule.